from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Welcome to the third week in our 8-week series entitled Know the Law. And for our viewers who were not with us during the first 2 weeks, what we're doing during this series is taking a particular aspect of law that we think is of great interest to you and help. And we are inviting attorneys on the program to discuss some of the suggestions that could be helpful to you as you address these particular questions. On program number 3, we're going to deal with the issue of bankruptcy, and we're very fortunate to have 2 guests today that are highly qualified to address our questions. I first of all welcome to the program, to my far left, Mr. Wayne Sweeney, who is an attorney practicing in Coeur d'Alene and has had years' experience addressing this issue, and we've had him on the program about 12 years ago to deal with bankruptcy. Wayne, welcome back to the program.
Thank you, Tony. I'm glad to be here.
We're very pleased to have you, and I'm equally happy to welcome to the program Carolyn Just, who is also an attorney in the state of Idaho. She too practices in Coeur d'Alene and like our other guests, is highly qualified in the field of bankruptcy. And Carolyn, it's a pleasure to welcome you to the program.
Thank you. Glad to be here.
I know that you've taken time away from your practice to do this, as a number of other attorneys have, and we've gotten total cooperation from the local bar and the attorneys, and we're very grateful. As always, I'm most pleased to have a regular panelist, Janelle Burke, who is also an attorney in the state of Idaho, and in fact, I'm the only only person on the program that's not an attorney today. She is also the law clerk to Judge Heyman, and so we're pleased to have her here, and we would invite Janelle to commence the questioning.
Well, Wayne, let's start with you from a creditor's perspective. Some of the people who may be watching may be those individuals who have loaned money personally, or it may be that they're involved in a small business, or perhaps they know someone who has loaned money. What kind of advice would you give prior to the time that an individual suspects that the debtor may have a difficulty with bankruptcy? What kind of advice would you give with respect to creditors? Where should they start?
Well, bankruptcy planning for the creditor begins when the decision is made whether or not to extend credit. And there are provisions in the bankruptcy code which give some guidance in addressing that question, and the provision I have in mind arises under the section of the bankruptcy code which accepts some types of credit transactions from discharge on grounds of fraud. And within that provision of the code, there's a statement that the creditor must reasonably rely on the written information or information provided by the debtor in obtaining the credit. And that indicates to the prudent creditor that, first of all, the creditor should get information about the debtor, financial information, credit history, and determine how that particular debtor has handled its credit in the past. And then not only must that information be obtained, but the creditor should go further and make some effort, reasonable effort, at verifying the credit. Usually this will consist of at least of a credit bureau report, perhaps contact with creditors of that particular debtor, which are disclosed in the financial statement. But it's important for the creditor to get as much information about the debtor to make sure that there's a reasonable likelihood of performance on the credit obligation before extending the credit. Now, certainly there are a range of circumstances under which that will be appropriate. If it's a loan from an individual to a relative, it's unlikely that that type of sophisticated credit search would be done. But aside from that, where it's more of an arm's length type of credit transaction, the creditor it really has an obligation to the creditor's best interest to do the investigation, get as much information as possible about that particular debtor, prospective borrower. Secondly, once that information is determined and obtained, the creditor can make an informed decision, or should be able to make an informed decision, on how much credit to extend to the debtor, what the terms should be, whether or not the obligation to repay should be what we call secured or unsecured and the interest rate, which is usually a measurement of risk, and the term of repayment. Obviously, in a bankruptcy case, the creditor who has what we call a secured obligation, in which the debtor has pledged to the creditor some property of the debtor that allows the creditor to have recourse against that property in the event of default, is better protected, because a bankruptcy discharge operates as a permanent injunction against the creditor ever collecting that debt. The debt still exists even after a bankruptcy discharge. It has not been repaid, it's not satisfied. It's just that under the federal bankruptcy code, the discharge operates as an injunction to prevent the creditor from collecting it. But if the creditor has a valid enforceable lien or security interest in property of the debtor, then even in bankruptcy, the creditor is allowed recourse to that property. And that's why if there is a reasonable risk of default, that a prudent creditor will consider obtaining security interest in the property of the debtor to secure the claim. So there is some recourse. It may not be 100% recourse, but at least there is some.
Well, we've talked then a little bit about those two steps, and I want to turn to Carolyn in just a minute, but what if that debtor defaults then? What is the best thing that can be done next?
Well, if we're talking about a pre-petition situation?
Yes, pre-petition.
Well, usually, depending on whether or not the obligation is secured or unsecured, the creditor will have to make some decisions. Usually, if the obligation is unsecured, the creditor's most effective enforcement remedy is to file a legal action against the debtor to compel court enforcement of a recovery of the obligation. And generally the claim on that track is reduced to a judgment in which the court orders that the creditor recover the unpaid balance of the obligation from the debtor's property. And then the process goes forward under the terms of the judgment and the statutes of the state. Usually the judgment creditor at that point can get what's called a writ of execution from the clerk of the court, which directs the sheriff then to go out and seize non-exempt property. And non-exempt property is property which is available for execution. There is some property which the state laws provide will be exempt from satisfaction of claims of creditors. And I know that's an important element of debtor bankruptcy planning or credit planning, so perhaps it's more appropriate that Carolyn address that. But in any event, that's the non-bankruptcy way of enforcing payment or attempting recovery on the debt. Wages can be garnished. As I said, non-exempt assets can be seized and sold by the sheriff and liquidated, and the proceeds applied towards the debt. And on the other track, if the creditor was prudent enough to have some amount of the debtor's property pledged to secure the claim and a valid enforceable lien on the property, then either in the same court action or a separate action, or possibly under some circumstances self-help without the aid of the court, the creditor can have recourse against the property depending on what type of property it is. But those are the primary methods, short of pre-bankruptcy proceedings in which a creditor can enforce recovery of its claim.
So we've kind of talked about this from the creditor's point of view pre-bankruptcy, but now let's talk about it from the debtor's point of view, Carolyn. What kinds of things can debtors do if they begin to find themselves getting into trouble? Where should they go? What should they do?
Okay. Number of things come to mind. First of all, Wayne mentioned a creditor obtaining a judgment against someone as a basis for then proceeding to reach assets, be that wages or other non-exempt assets. Clearly, at the point that someone is being sued, at that point they need to be really actively inquiring and getting an analysis of their situation to determine what's going on, because once a judgment is entered, a creditor then proceeds to attach wages. That can affect a person's job situation. A creditor can reach out and take money that's in a bank account. Maybe that money is taken from the bank account before the checks that were written to the landlord get there. Perhaps the judgment is recorded, in which case it becomes a lien on that person's home and will affect their ability to later sell their home. So planning clearly needs to take place at that point. People do need to pay attention to what kinds of debts are they undertaking that are backed up by collateral. This is something I run into quite a bit, that I will ask people which creditors they have that have liens, and they'll tell me their home and their car and maybe another debt or two, and as it turns out, they have purchased durable goods at Sears on their Sears card. Sears has a lien. They have gone into a small loan company and may not have been paying very close attention to what they were doing, and when they were asked about what kinds of assets they had, those assets were being listed and they were giving a lien on those assets. And the paperwork clearly shows that's what's happening, but they weren't paying attention that they were giving a lien on those assets, and that it may well be assets that they really, under no circumstances, want to part with. Wayne mentioned the need for a creditor to make inquiry. The debtor has a responsibility to be truthful and forthright in making the disclosures with respect to their financial situation. And that's a problem sometimes on forms that have just a little short line that says list your debts, and here's a little short line, and people put down the couple, 3 debts that they have that are the largest. They need to make a full, complete disclosure. One thing that I see people doing that concerns me is, with the availability of second, third, fourth mortgages these days, people are jeopardizing their homes in situations sometimes where they have no ability at all to pay that loan. And they're a person who has some equity in their home that is protected. In Idaho, the protection is up to $50,000 of equity in a person's home is protected. That varies from state to state, but that's what it is in Idaho. If the person goes out and is making a last-ditch effort to avoid a bankruptcy and borrows money and puts a lien on their home and then cannot pay that payment on that loan, they're going to lose their home. And their homestead is no good against that creditor. So it would be quite one thing if that loan was going to solve the problem and they could avoid a bankruptcy. It's quite something else if that loan merely sets the stage for them not only having to go through bankruptcy but losing their home. People have to pay attention to the priorities of what needs paid first. When the paycheck isn't enough to cover all the expenses, you have to pay attention to the rent so you don't find yourself in the street. If you need a car to get to work, you have to keep making those car payments. You don't have to respond to whichever creditor is yelling the loudest when you have a limited supply of dollars. And I see this in the small business setting, with a small business perhaps that is struggling and the people are trying to keep their heads above water, and the suppliers are right there to demand their money, and the money's not there, so they pay the supplier using the money that should have been turned over to the government in taxes from money withheld from wages from an employee or whatever, because the government wasn't there every Friday to demand payment. So those are some of the kinds of things that I see that as people realize they're in financial problem is worth paying attention to.
Real quickly, I want to go through some of the kinds of bankruptcy. And people oftentimes talk about the numbers. What is a Chapter 11?
Chapter 11 is a business reorganization.
And Chapter 12?
Chapter 12 is a family farmer bankruptcy.
And Chapter 13?
Chapter 13 goes by a couple different names. It's an individual debt reorganization. It's sometimes called a wage earner plan, although that's not really accurate. That's an old term. And I might just mention Chapter 13 is not just a debt consolidation loan variation. It is typically some reorganization and some debt elimination.
And Chapter 7?
And Chapter 7 is what's called your straight bankruptcy or full bankruptcy or liquidating bankruptcy.
What we need to do is get into more detail on that. You both have done an excellent job of talking about the role of the debtor and the creditor. I'll start with Wayne and then come over to Carolyn on this. When we talk about what Carolyn just talked about concerning Chapter 11, Chapter 13, and Chapter 7 and so forth, are all bankruptcies that come under these particular headings all under federal law, and also that when one has to go through bankruptcy, one has to do it through a special federal court? Is that correct?
That's correct. The bankruptcy court system is actually established in the U.S. Constitution. It's provided for there that Congress will provide for bankruptcy relief, essentially. And it's administered entirely by a special court system, again established by Congress, the U.S. bankruptcy court system, which are divisions of the U.S. district courts in each district, in each state. The basic fabric of bankruptcy law then follows by the United States Code. It's established under Title 11 of the United States Code. State law has a role to play. I mentioned exemptions earlier. Exempt property is property which cannot be made available to pay creditors' claims, and those exemptions are usually specified and provided for by state law, not bankruptcy law. Although the Bankruptcy Code in 1979 did provide for a scheme of federal exemptions which a debtor could take in lieu of the state exemptions, several states have opted out of that, Idaho being one. Washington still offers the option. I'm not sure about other neighboring states as to whether or not they've opted out or not, but and matters of property law, what is and is not property is a determination made by state law, not by federal law. The federal bankruptcy code may specify what happens to that property in the bankruptcy proceeding, but it doesn't state what the aspects of that property right might be.
I'm going to have you both to go in different areas. I'll go over to Carolyn now. I know that one of the areas that you specialize in this is the debtor, from the debtor, and I know that Wayne is, both of you know about both, but he deals a lot with the creditor questions. Someone comes to you and they're in deep trouble financially, and you've looked over it, and you're convinced that bankruptcy is the only resolution. Mm-hmm. Could you take us kind of through the steps of what you would say to this person, and as Wayne has indicated, how you go into bankruptcy? How does the process work, and how do they come out of this somehow able to at least get to work and continue to survive?
Okay. The first step really is to be able to get an overview of the person's situation, yes, to know what their debts are, and how those debts fit into the different categories. In other words, do they have tax debts? Do they have debts that are backed up by collateral? Do they have just some general debts? Do they have some judgments? Are there wage attachments in process? That kind of thing. And also to determine what their assets are and what their income is. Because, for example, if a person just barely has enough to keep paying the rent and put gas in their car and food on the table, they can't fund a Chapter 13 plan, which would provide for some restructuring of debt or some repayment of some debt. So once I get that information to understand what the client's situation is, then I can explain the options. And most of the time, since Chapter 11 is a business reorganization and technically it may be available to an individual, but unless an individual is very wealthy and needing some restructuring of their debt, it's really not appropriate. So the choice narrows in 99% of the cases down very quickly to Chapter 7 or Chapter 13. And most of that comes to a question of does the person have some ability to be paying some of their debt through an organized plan, or do they need to eliminate debt and then get on with their lives? It also involves a decision or some determinations as to what assets are they going to be able to keep and how important is it to keep those assets. For example, in Idaho, we have $1,500 is the exemption amount for a motor vehicle. And if it's a husband and wife, that totals $3,000. Well, if the couple has a $6,000 car that they own free and clear and that they've got to have as the way to get back and forth to work, and they don't have credit, then that may be the factor that steers that situation into a Chapter 13. Once we make a decision, there's quite a bit of paperwork, as there is in anything that you get involved in a federal proceeding. It's quite a bit of paperwork gathering the financial picture. We file the bankruptcy. A few weeks later, we go to court for what technically is called a Section 341A hearing, what is known commonly as a first creditors meeting. And at that time, the debtor testifies that their information that was provided is accurate. The bankruptcy trustee can question them to get a fuller financial picture. The creditors or their attorneys can make inquiry, and it's not a free-for-all. People get very panicked in anticipating that going to court. For most people, their time on the witness stand is 5 minutes or less, and they are not torn to pieces by their creditors. And then a couple months later, they receive their bankruptcy discharge if there's been if, for example, a creditor hasn't filed saying that a debt is non-dischargeable because it was incurred as a result of fraud or theft or some deliberate wrongdoing. And in that process, if there are assets that are going to be lost in the bankruptcy, then the bankruptcy trustee makes arrangements and collects those assets from the debtors.
But there are so many individuals where they would not have any assets, and others where they would. I understand you say they can take a lot of those assets, but if they have nothing and they've got really a lot of debt, and once the bankruptcy is finalized, is that almost like it's forgiven, or will they be responsible sometime in the future?
No, that debt is discharged. That debt, the creditors are prohibited by what amounts to the federal court order, the discharge order that's entered. Creditors are prohibited from continuing to pursue that debt. Now that applies to debts that are going to be wiped out, and there's a contrast there. For example, if I file a bankruptcy for someone who owes taxes income taxes from 1993, and we go through the Chapter 7 straight bankruptcy, they're still going to be owing their 1993 income taxes. They're not going to get rid of that. That's an example of a non-dischargeable debt. If my client has a loan on their home loan is not going to be wiped out because it's backed up by value in that collateral. Same way with their car. So we have to break the debts down into the categories to analyze what's going to happen.
But if they're in Chapter 13, it sounds like to me, from what you're saying, that Chapter 13 is more drastic than 7, or is that not true?
No. Chapter 13 enables you to in a typical Chapter 13 case, it enables the person to hang on to assets that they would have lost in a straight bankruptcy. And the way they do that is by paying money on a monthly basis over what's usually a 3-year plan and that money goes to the bankruptcy trustee and either on its way to the general unsecured creditors or on its way to the secured creditors whose debts are being reorganized.
On the original one in Chapter 7, and if all those debts are taken care of through this process, if down the road later they wish to borrow, it becomes very difficult, doesn't it, after they have this record? I mean, there are disadvantages of also having to go through bankruptcy.
There are, and it's difficult. It's difficult to predict exactly how that's going to work out because, number one, the person does start rebuilding a credit picture when they make their next rent payment, when they make their next car payment, and so on. It also depends upon what their income is in the future. It depends on how tight the money supply is. Are lenders anxious to lend? And who they're borrowing from. Are they borrowing from a bank? Or are they borrowing from a small loan company? Those are certainly factors. I think the misconception is that people get a notion that they are choosing between shall I have good credit or shall I file a bankruptcy. The reality is that by the time people are in talking to someone like myself, they either already have bad credit or the writing is on the wall and it's very clear that they are not going to be able to keep up and they're soon going to start having no pays, late pays, and judgments and attachments and that kind of thing showing on their credit record.
And a lot of legal questions and problems sometimes. Wayne, this time is just flying by, and I want to talk about Chapter 11 for a minute that Carolyn has already pointed out that deals oftentimes with corporation reorganization and so forth. Can you take us through some of the characteristics of some of our viewers that might be watching that would be in this category?
Well, there are similarities in concept between Chapter 11 and Chapter 13. Carolyn has indicated that one of the objectives in Chapter 13 is for the debtor to make the best effort the debtor can to repay the debtor's obligations, given the circumstances of income and assets and so forth, which mix into the formula on the repayment plan. The concept is similar in Chapter 11. Generally, there are much larger numbers involved, companies or individuals with a substantial amount of assets. One present restriction on Chapter 13 is that there are ceilings on the amount of debt that an individual can have and qualify for relief under Chapter 13. I believe it's $100,000 in unsecured debt is the ceiling, together with $300,000 in secured debt. If a debtor has more than that, even if it's an individual, then the debtor has to proceed for relief under Chapter 11 if the debtor wants to try and reach a plan of arrangement with its creditors. Once the Chapter 11 petition is filed, the code provides that the debtor, be it a corporation or an individual or a partnership, will remain in possession of its assets and operate its business unless the court, for good cause shown, appoints a trustee to take possession of the business or assets. The debtor then has a certain amount of time, 120 days, in which to propose a plan of reorganization to its creditors. And then that plan can provide for payment to the creditors who have secured claims, which I mentioned earlier, which would be those creditors which have valid enforceable liens in the property of the debtor, as well as unsecured creditors, as well as priority tax creditors.
So the secured creditors would come first, is that correct?
No, the priority creditors, the tax obligations,
Okay.
administrative expense claimants, and so forth would have the priority.
And then
payment.
secured next.
Secured creditors.
We have 1 minute, that's the reason
Secured creditors are in a classification by which
Okay.
they must be paid if the debtor is going to retain possession of the property, and then the unsecured creditors generally share in a pro rata class by themselves.
I'm just so sad to say that we're out of time. I know Janelle joins me. I could tell she had many more questions to ask, and I want to thank both of you on behalf of our staff for being with us. It's been extremely informative, and we'll have you back at some later date because we just got started. Ladies and gentlemen, I hope you found our program most informative and helpful to you, and I would invite you to be with us again next week when we will do program number 4 in this 8-week series. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.